Getting ready for your Hong Kong constitutional law exams? Well, if you are, you've absolutely got to get your head around the core tension at the very heart of its legal system. In this explainer, we're going to break down the essential principles you'll be tested on, from one country, two systems, all the way to the national security law. So yeah, let's dive right in.
Okay, so here's our game plan. We're kicking things off with the foundational one country, two systems principle. Then we'll unpack the two competing constitutional theories that everything really rests on. From there, we'll dig into how the basic law tries to strike a balance, see how the 2014 white paper and the national security law have shifted things, and then, most importantly, we'll lock in those key takeaways that are going to make a real difference in your exam.
All right, so first things first, we have to establish the foundational principle. Honestly, this underpins pretty much every single legal question you're going to face on this topic, one country, two systems.
You know, at its heart, one country, two systems is this truly unique constitutional experiment. It's really an attempt to manage the coexistence of two profoundly different systems. You've got the socialist system of mainland China on one hand and the capitalist common law system of Hong Kong on the other, all inside a single sovereign state. For your exams, you should think of it as a promise of continuity, but one that also contains the very tensions you'll be asked to pick apart.
Now, to really understand the challenges of making one country, two systems work, and, to build a truly top-tier legal argument, you have to get the two conflicting constitutional philosophies it's trying to bring together. This is where the real action is.
And this is fascinating because it just crystallizes that fundamental disagreement so perfectly. On one side, you have the liberal democratic tradition, which is probably very familiar to you from common law. Here, a constitution's main job is to limit state power and protect individual rights with an independent judiciary as the ultimate guardian. But on the other side, you have the socialist tradition, which sees the state, led by the party, as the engine for achieving collective goals. In that view, the judiciary is another organ of the state working towards those same goals. It's not meant to be an independent check on them. And this clash, it's everything.
The legal scholar Yash Gai just absolutely nails this point. This isn't some dry, technical legal debate we're having. It's about fundamentally different views on the whole purpose of law itself. So, is law a tool to achieve political aims? Or is it a framework that stands above politics to regulate state power? That question is at the very core of every issue we are about to discuss. So, okay, given these totally opposing philosophies, how does Hong Kong's mini-constitution, the Basic Law, actually try to bridge this huge divide? This is where we need to roll up our sleeves and get into the text itself, which, by the way, is exactly where any good exam question is going to send you. So, on one side of the scale, you have articles that firmly establish that one-country aspect. The preamble in Article 1, well, they leave no doubt. The Basic Law is a national law of China, and Hong Kong is an inalienable part of the PRC. This is what anchors Hong Kong within China's sovereign and constitutional framework. But then, on the other side, you have these really powerful provisions that carve out the two systems. Article 5 protects the capitalist system, Article 8 preserves the common law tradition, and, so crucially, Article 19 vests Hong Kong with independent judicial power. These are all designed to maintain the city's distinct legal and social fabric.
And check this out. This table is just a perfect illustration of how that balancing act plays out within single articles. Take Article 17, for example. Hong Kong has its own legislative power. That's the autonomy part. But those laws have to be reported to the National People's Congress Standing Committee, the NPSC, which can invalidate them. And that's the sovereignty part. You see the same dynamic in Article 158 on legal interpretation. It's this constant negotiation between delegated power and ultimate authority, and it's a prime area for you to analyze.
Right, but this delicate balance, it isn't static. It's not frozen in time. Over the last decade or so, some really key legal and political developments have tested it, and, you could argue, have started to redefine it. A really major moment came back in 2014. The State Council in Beijing released a white paper on the 1C2S principle. Now, the paper's stated aim was to address what it called wrong understandings of the concept that it felt had emerged in Hong Kong. So, the crucial point here, and you need to get this, is the framing of autonomy. The white paper really emphasizes that Hong Kong's autonomy isn't inherent. Instead, it's granted by and is therefore subordinate to the central government's overall jurisdiction. It very clearly positions one country as the premise for two systems. And as you can probably imagine, this sparked a massive debate. A key flashpoint was the statement that all administrators of Hong Kong, including judges, have a basic political requirement to be patriots. This raised some profound questions about how you reconcile the idea of political loyalty with the principle of judicial independence, which, as you know, is a cornerstone of the common law system. Well, these constitutional tensions just kept on building, and they led to the events you see right here on this timeline. After an attempt to pass local national security legislation under Article 23 failed way back in 2003, and then following the huge protests in 2019, the central government decided to take a different path. In 2020, it enacted a national security law, or NSL, for Hong Kong directly, bypassing the local legislature entirely and adding it to an annex of the Basic Law.
So, for your legal studies, this is the absolute crucial takeaway about the status of this new law. Hong Kong's highest court, the Court of Final Appeal, has since ruled that the NSL cannot be reviewed by local courts for being incompatible with the Basic Law. Now, what does that mean? It effectively gives the NSL a parallel, almost quasi-constitutional status. It operates alongside the Basic Law, not beneath it. And that's a huge deal, legally speaking, and a critical concept to grasp for any problem question involving the NSL.
Okay, let's pull all of this together. For your revision, the key is not just knowing these facts and dates, but actually applying this entire framework to analyze complex legal questions. Let's see how that works in practice.
Take a look at this. This is a classic exam-style question. See how it doesn't ask for a simple yes or no? It asks you to analyze one of those core tensions we've just been talking about, using the legal and constitutional principles we've covered.
To build a truly first-class answer here, you have to connect all the dots we've just laid out. You'd start by analyzing the competing definitions of patriotism versus judicial impartiality. You'd then contrast the liberal democratic view of judges as independent arbiters with the socialist constitutional view of their role as part of the state administration. You'd weigh the White Paper's emphasis on central authority against the Basic Law's explicit guarantee of judicial independence in Article 19. Ultimately, a strong analysis requires you to use this fundamental conflict between the two constitutional theories as your guide. Which set of principles prevails when they collide? That is the central constitutional question you are being asked to answer.